All right, moving forward, amidst the ongoing perpetuated standoff between the centre and the Supreme Court, Chief Justice of India D.Y. Chandrachud makes a big remark, says no case is too big or small for any of the courts in the country. Now, this is the second time that he has made such remarks in the past week. Now, this comes in the backdrop of Law Minister Kiren Rijiju criticizing the Apex Court, blaming them for failing to fill up vacancies, which is leading to justice being delayed. Rijiju had also suggested that the Apex Court should focus on key constitutional matters instead of bail pleas and PILs.
Sermonizing apart, trust us to be guardians of the liberties of our citizens. And there is no case which is small enough or big enough for every court in the nation, be it the district judiciary, the High Court, or the Supreme Court. Because it is in us that the confidence of the citizens in the due process of law and the protection of liberty rests. And it is through the lives of the members of the bar who fearlessly espouse those causes that the flame of liberty burns bright.
And to give us more inputs on this report here, I am joined by my colleague Harish on the phone line. So, Harish, for the second time, Chief Justice of India has made such a big statement that no case is big or small for the courts in India. So, is it again hinting to the fact that he wants politics to stay away from judicial matters? Over to you, Harish.
Yes, in fact, this was Chief Justice of India, D.Y. Chandrachud, delivering his first speech in Mumbai as the Chief Justice of India at the Ashok Desai Memorial Lecture yesterday. This is, as you rightly said, this is the second time that the Chief Justice is indirectly responding to the Law Minister's criticism of the way Supreme Court is functioning. Remember, the Law Minister had recently said that, while speaking in the Parliament, said that Supreme Court should focus on bringing down the pendency in Supreme Court, which stood at 70,000 cases at present, and focus on constitutional matters rather than hearing bail applications and public interest litigations. So even 2 days back on Friday, in the Supreme Court, Chief Justice, while hearing a matter, had said that our duty is to interfere in matters of personal liberty. Wherever we see there is a violation of personal liberty, we burn midnight oil to settle it. And no case is too small or too big for us. And he had made these comments while ordering release of a man sentenced to 18 years for a simple electricity theft. He wondered whether was this a murder case to sentence a person for 18 years, and he had already spent 3 years in jail. And considering issues of personal liberty, Chief Justice bench had ordered the release of that person. Chief Justice once again yesterday repeated this statement and also said that trust us to be the guardians of citizens' rights and liberties and know that no case is small enough. And he had cited the Supreme Court case in which this person was released, and had said that our Constitution is an educational document which tries to create a new moral order in the society. However, principles of non-discrimination and substantive equality will only be effective if social satisfaction is ironed out to create an equitable society. So our emphasis will continue to be dealing with matters where violation of personal liberty is noticed, and therefore no case is too big or small before us. All litigants are the same.
All right. Thank you so much, Harish, for all those inputs.